When our station needs a mugshot or other information, we are only able to obtain that information with a FOIA request. FOIA stands for the Freedom of Information Act, a law that gives citizens the right to access information held by the federal and state government. The Sugar Law Center for Social and Economic Justice went to Marquette County Circuit Court to uphold that statute on benefit of the concerned citizens of Big Bay. ABC 10's Rick Tarsitano was there.
Thank you. You may be seated.
In December of 2007, Michigan's Department of Environmental Quality issued a mining permit to Rio Tinto, prohibiting them from using or building an electrical infrastructure, only allowing for generator power. 1 month later, a nonprofit organization called the Northern Michigan Geologic Repository Association was formed by members of the Department of Environmental Quality, the Department of Natural Resources, Bitterroot Resources, and Rio Tinto to manage facilities housing mining core samples.
Well, that's why we're here in front of the courthouse today, because state employees created it, organized it, and joined it, and ran it with mining executives. The organization itself is saying, you're not subject to Freedom of Information Act requests.
But why would anyone seek out a FOIA request from a Coreshed nonprofit organization? Fast forward to November of 2008, where the DEQ sends a letter to Rio Tinto allowing them to build an electrical infrastructure solely for their coreshed and not the mine itself. The DEQ ruled that the coreshed was not part of the mining process, and in turn the permit was not subject to public procedure under Part 632 of mining law.
The fact was that was a total of almost 9 megawatts of power going up that way, and Big Bay, Powell Township along 550 has always used, since electricity's been there, no more than 3 megawatts of power. So all that extra power was obviously going to power a coreshed, according to them, when that's basically a big garage, and they could have run electric lines from Big Bay Sportsman's Club out that way if that was their true intent. We had assurances from the DEQ that once it started down 510, they would have to file amendment to the permit. That was never done until the wires poked out of the ground outside the fence, and then, oh my God, there's electricity there. Why don't we put electricity to the mine? But as soon as the electricity was hooked up to the mine and they got the permit for the mine, all of a sudden that coreshed was decommissioned. People at the time questioned why they didn't have to go through the permitting process, and that's the biggest question that I have, is if we are supposed to have the toughest mining laws in the country, they're worthless unless the process is followed. In this case, the process was not followed.
Which brings us back to the FOIA request and the current court case.
I have a great interest in this case, mostly because over the course of the last 12 years, we've watched the DEQ and mining companies work almost a little too closely together on some issues.
This is a complaint filed by the
Issues like forming a coreshed nonprofit organization comprised of former regulatory officials and mining executives alike, who work hand in hand with the Department of Environmental Quality, who is supposed to be analyzing the toxicity of core samples stored in warehouses that belong to the Northern Michigan Geologic Repository Association.
And they're saying, we're not a public body. Well, you have a choice here. You're either a public body, and we know that you are because state officials created it. It fulfills a state mandate to maintain cores. The other option is you're serving private interest, and you violated the Internal Revenue Services provisions that say you cannot be a nonprofit corporation and solely serve private interest. But we're going to let Judge Solka figure that out today.
right, taken under advisement.
The case continues August 9th. Until then, I'm Rick Tarsitano reporting for ABC 10 and CW5.